You are now tuned into the Black Law Students Association of Canada's YouTube.
Thank you for your attention, and without further ado, I will now cede the floor to our Honorable Justices of the Diversity High Court of Canada, Justice Yola Grant and Justice Jeremy Tatum.
Thank you, Mr. Dew, and welcome everyone. My co-panelist, Justice Tatum. We will begin in the usual course with the appellants. So I'd like to ask the appellants to unmute and to introduce themselves, and we will begin.
Awesome. Am I good to begin now?
Yes, I believe so, without further ceremony.
Okay. Good evening, Justices. My name is Jacqueline Ebo. Jacqueline. Last name Eboh. And my co-counsel, Catherine Cinerari, are here today representing Mr. Williams, the appellant. Justices, this case is not only about the right to equality, it is also about the extent to which the government of Canada has an obligation to uphold this right and address systemic barriers that affect the equality of racialized communities, because if not now, then when? Groups that have been historically the targets of discrimination cannot be expected to wait patiently for the protection of their human dignity and equal rights as they die. To that end, the pursuit of justice and equality cannot be colorblind. The appellant, Mr. Jamal Andrew Williams, is at the forefront of this case, ensuring, no, fighting, that racialized communities benefit from this right in the same way of those who benefit from white privilege. The decision of this case will have impacts that will ripple through society. This case will determine whether the status quo that has been proven to be ineffective to every individual in Canada will remain, or if the change needed in a free and democratic society for Black people will begin today, starting with the Canadian healthcare system. The appellant respectfully asks this court to find that the Supreme Court of Canada erred in finding that the appellant Section 7 and 15 charter rights were not infringed. First, the appellant Section 15 rights were infringed because the failure to collect disaggregated race-based data creates a distinction that is discriminatory. Should the court find that this case is about positive and negative obligations, it is a submission of the appellant that the courts are within their purview to impose positive obligations on governments and that costs do not outweigh equality when it comes to race in this country, especially because of the deep, historical, systemic discrimination ongoing in Canada. Second, the appellant Section 7 rights were infringed. And third, the infringement of both the appellant Section 7 and 15 rights cannot be saved under Section 1 of the Charter. Will the courts care for a brief recitation of the facts?
Speaking for myself, that's not necessary.
Also, that's not necessary. But before you go on, I wanted to understand something you've said already, that you're seeking for Mr. Williams that he benefits in the same way as those who benefit from white privilege.
Absolutely.
Are you going to expound on that further?
Yes, Justice.
I'm waiting for that.
Okay. Turning to paragraph 41 of the appellant's factum. The appellant submits not collecting disaggregated race-based data infringes on Section 15 of the Charter because it creates a distinction that is discriminatory on Black lives. The collection of race-based data is not about positive or negative obligations on the government. In actuality, It is about the constitutional duty the respondent has to uphold in this country for every single individual. Section 15(1) of the Charter states that every individual is equal before and under the law and has the right to equal protection without discrimination based on race, national, or ethnic origin and color. In the Queen and Cap, the Supreme Court of Canada refined the Section 15 analysis originally laid out in law in Canada. This became a two-step legal test. The first step of the test to determine whether there has been a violation of a person's Section 15 rights is by looking at whether the law has created a distinction on enumerated or analogous grounds. Turning to paragraph 42 of the appellant's factum. The appellant submits that the respondent failing to collect such data creates a distinction on the ground of race. Justice McIntyre described distinction in Andrews as something based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others. Or,
Ms. Ebo, what data is it that you say that the government should specifically be collecting here and would need to collect in order to not infringe your client's Section 15 charter right?
the appellant admits that the data needed would be disaggregated race-based data. So how the COVID-19 pandemic is affecting Black people and at what rates. Turning to paragraph 43 of the appellant's factum. The distinction in this case—
Before you go on, I saw throughout your written submissions reference to the fact that there is data to suggest that people of color, BIPOC, Black, and Indigenous and people of color are more affected and experience, higher rates of infection as well as lethality. Isn't that data already race disaggregated? What more specifically are you seeking?
Justice, the data that we have right now is not enough. The data needed is data that can adequately be studied and identified to figure out why indeed COVID-19 rates are hitting Black communities at a much higher rate. It is to understand who is being affected, understanding what areas are being affected, and how they are being affected in the COVID-19 pandemic. And also we need this data on a federal level as well, and not just provincial.
Okay.
So who would be the source of that data then? Would that be something that the government rolls out like a census? Or is that data that would also draw upon the scientific community in order to, as you say, understand why it is that Black people are being affected at a disproportionate rate to white people? And
The appellant submits that it would be both scientific and governmental. It would also be based on community consultations. It will also be based on Black leadership, Black doctors, and Black people within their communities. Turning to paragraph 42 of the appellant's factum.
Before you continue, I'm curious to know, because I have read your submissions, I've read all those paragraphs. I'm curious to know, and I'm trying to get to my comments that I made, and I'm having a bit of problem with my mouse. Okay. At paragraph 43, you speak and you recited this out loud, that the failure to collect race-based data creates a distinction in the standard of care received by BIPOC. And the word creates, that verb stood out for me, and I'm wondering, what are you pointing to specifically where the omission to collect actually creates a distinction? Could you expand on that? Because that makes it seem like the omission is itself active.
Thank you, Justice. The appellant submits that the omission is in fact acting because the standard of healthcare in Canada is based on the idea of whiteness. Whiteness being a dominant cultural space with enormous political significance, with the purpose to keep others on the margin. White people are not required to explain to others how white culture works because white culture is the dominant culture that sets the norms.
No, I understand that. And you're reading from paragraph 43. I'm looking for something more that's not on the page.
Okay. Justice, may I please ask you to repeat your question?
All right, maybe it will help if I take you back to paragraph 39, where you're setting up the section 15 argument. Argument number 2, individualistic approach to human rights. And you speak to individualism, while important, fails to protect the rights of groups. But here in paragraph 39, where you talk about ethnocultural communities, I didn't see any reference there to groups being defined in a way that would distinguish, let's say, Northern European ethnic groups within Canada. Like, you know, do Polish immigrants require particular protections? Do Lithuanians? And I'm looking for something more specific that harkens to historically disadvantaged groups, as we typically understand them, who are defined largely because of subjugation, because of slavery or colonialism. And not just any ethnic group, or, you know, the merger of, you know, Northern Europeans and Anglos into this blob that we call whiteness. I didn't see in your written materials the specificity that would draw our attention to race and the fact that people are marginalized for historical reasons that play into, you know, intergenerational experiences of wealth, health, and on the right track in reading that into your definition of ethnic groups, that you're referring there to colonized people and not Northern Europeans who themselves are ethnically identified. It's a question. I need you to say yes or no. You know, am I reading it correctly?
Yes, Justice, you are correct. We refer to colonized and racialized people.
Okay, and that's somewhere in your materials?
Not in our factum, no, Justice.
But so I'm to read that in?
Yes.
Very well. Continue.
Thank you. Turning to paragraph 46 of the appellant's factum. Next is to determine whether the distinction is discriminatory. Healthcare in Canada is usually results to systemic and indirect discrimination. Indirect discrimination takes place when exactly the same services are provided to everyone, so they seem fair, but the members of a disadvantaged group do not benefit equally. This is otherwise known as the colorblind approach, which is rooted in the belief that racial group membership and race-based differences should not be taken into account when decisions are made, impressions are formed, and behaviors are enacted. Treating all people the same in this country reinforces the dominant cultural norms and does not recognize systemic racism, which is discriminatory in nature and does not recognize substantial equal access. It should not be legal to set up healthcare or pandemic strategies that predictably do not meet the needs of Canada's diverse populations. It should not be legal to be deliberately blind to health disparities. Canada is a multicultural country which claims diversity as a strength.
Ms. Eba, one of the submissions that your friends make is that there's not actually any evidence of your client being denied access to healthcare. He still has the ability to be seen at the hospital and is still covered by the public healthcare system. I wondered if you could help us with that point. I think you just started to, but I'm wondering if you could develop that a bit further, just to clarify and assist us with your response.
Absolutely. Although the appellant is able to get standardized healthcare in Canada, as discussed before, the standard of healthcare is whiteness. So that is the norm in which the Canadian healthcare system is holding the appellant to, and the appellant and all Black communities cannot meet this norm because they don't get to benefit off of the idea of whiteness and white privilege. So they are not afforded adequate healthcare services if they are using this norm as the basis and foundation for the standard healthcare in Canada. Turning to paragraph 46 of the appellant's factum. There continues to be racist assumptions within the healthcare system, and these assumptions produce inadequate healthcare. There are diseases that appear with greater frequency in certain racialized groups. For example, according to the CDC, 1 in every 13 African-American children are born with the sickle cell trait, the precursor for sickle cell disease, which results in 8 to 10% of all sickle cell cases being held by African-Americans. The data has not been collected for African Canadians, and disaggregated data is needed to track this to determine why this number is so high. According to Statistics Canada, COVID-19 has mortality rates higher in neighborhoods that have more visible minorities. Why is this? This question cannot be answered without disaggregated race-based data to find out the extent and severity of the impact on Black communities. Currently, the respondent is using a standard that continues to fail to respond to racial disparities. Whether there's an issue or not cannot be addressed until it is adequately identified. Turning to paragraph 47 of the appellant's factum. Section 2, subsection 2 of the Anti-Racism Act requires initiatives to eliminate systemic racism, including initiatives to identify and eliminate systemic barriers that contribute to inequitable racial outcomes. Should the court find that this case is about positive and negative obligations, the appellant submits that when it comes to section 15 of the charter, the court is within its purview to create positive obligations on the government. Recognizing the intersection between section 15 rights and positive obligations does not require a profound departure from past cases decided by lower courts. In Shader and Canada, the court held that section 15 of the charter is a hybrid protection since it is neither fully positive or fully negative, and that a government may be required to take positive steps to ensure the equality of people or groups who come within the scope of section 15. In Eldridge in British Columbia, the court held that section 15 guarantees the right to sign language interpretation in healthcare services, and although the choice and financial cost of such services is a governmental prerogative, doing nothing would have dismissed the rights of the deaf. In this case, Justice Laforêt explained that this court has repeatedly held that once the state does provide a benefit, it is obliged to do so in a non-discriminatory manner. In many circumstances, this will require governments to take positive actions.
And is your submission that the benefit conferred by the federal government here is healthcare? Public health care specifically?
That is correct, Justice.
Okay.
The respondent, by collecting data at all, has created a benefit for people in Canada, but has done so in a discriminatory fashion by continuing to use the standard of whiteness to collect this data. In the Queen and Dunmore, the court commented, a situation might arise in which in order to make a fundamental freedom meaningful, a posture of restraint would not be enough, and positive governmental action might be required. Finally, in Delisle in Canada, the court recognized that there are exceptional circumstances in which the Charter imposes positive obligations on the government. The COVID-19 pandemic is undoubtedly a time of exceptional circumstances. Therefore, the appellant submits that because of the systemic racism that has been evident in Canada when it comes to Section 15, positive obligations should be interpreted with this section of the Charter, because in a society in which discrimination already exists, there is no way to bring about equality without intentional government intervention, especially in circumstances in which the effect of their decision have discriminatory consequences. Finally, the appellant submits the infringement of Section 15 when pertaining to race not only should not be saved under Section 1, but should be excluded from the scope of Section 1. In a free and democratic society, discrimination is categorically unacceptable. To permit and justify inequality based on race does not only run contrary to the spirit of Section 15, but runs contrary to the Constitution. Justified, reasonable limits cannot play a part in systemic racism and the infringement of equality. As Justice Ikabuchi discussed in Vreen, groups that have been historically the targets of discrimination cannot be expected to wait patiently for the protection of their human dignity and equal rights as the government moves towards equality one step at a time. If the infringement of the rights and freedoms of these groups is permitted to persist, while governments fail to pursue equality diligently, then the guarantees of the Charter will be reduced to a little more than empty words.
I want to stop you there with your reference to Vreen and take you back to paragraph 51 of your factum, where you refer to Vreen and the imposition of a positive obligation to amend the statute. I believe it was a human rights statute in Alberta to extend it to include sexual orientation. You also rely on Big M Drug Mart and much earlier case to speak to making a fundamental freedom meaningful. Otherwise, the government's posture of restraint is simply not enough. My question to you is, how is not collecting granular data likened to freedom from discrimination based on, let's say, sexual orientation or freedom of expression, where in fact government restraint there is important? I don't see the relevance to using restraint in an environment where you're seeking actually to prompt government action, to do more, to collect more, rather than do nothing.
I'm sorry, Justice, may you please rephrase your question?
In Vreen, there was a decision that essentially broadened protections so that there was freedom from discrimination based on sexual orientation. So it broadened the protections. Are you arguing in this instance that in the Williams case that you're relying on Vreen essentially to say government now collects some data and they need to collect more granular data if they are to effectively serve certain populations, as opposed to Big M, which strikes me as not standing for the same principle, because there it's now addressing freedom of expression, where in fact restraint is in order.
Yes, Justice.
Do you see the distinction?
Yes, Justice.
Because when I read the respondents' factum, they make that quite clear. They're very strong on the restraint argument. It's very clearly articulated.
Yes, Justice. Unfortunately, in the appellant's factum in paragraph 51, what is listed as Big M Drug Mart should in fact be the Queen and Dudmore.
Okay, very well. So that's an error.
Yes, Justice.
Thanks for clarifying.
Justices, in conclusion, it is time to make the change that is much needed in this country. The Black community can no longer be left to fend for themselves in an equal, democratic society. Canada consistently ranks as one of the best places to live in the world, but this is not the case for all. There are significant socioeconomic disparities, and these lead to health disparities. Racialized groups, particularly Canada's Black populations, have an increased risk of a number of illnesses, poorer access to care, and worse health outcomes. The COVID-19 pandemic feeds on and exacerbates existing inequalities. Because of this, Canada's social and health disparities have major implications for the development of evidence-based effective pandemic responses. A one-size-fits-all strategy is unlikely to work in a population with diverse needs. Change can never come by accident. It must be intentional, aggressive, and forward-thinking, and in accordance with the long-held living tree doctrine that informs this country's constitution. If I could be of no further assistance to the court, these are my submissions.
Thank you.
Thank you. I believe it's time to hear further from your co-counsel.
Thank you, Justice. Shall I proceed?
Please.
Thank you. Good evening, Justices. My name for the record is Catherine Cinerari, Katherine Cinerari. I appear on behalf of the appellant, Mr. Jamal Andrew Williams. I will be addressing the issue of Section 7 and Section 1. It is the appellant's position that the Supreme Court of Canada erred in determining that Mr. Williams' rights were not violated. As you just heard my co-counsel explain, this case is about equality and the right to life, liberty, and security of the appellant and the Black community of which he is a member. However, this case is more than this. This case is about racial justice. It is about upholding and giving meaning to the very rights that we hold dear as Canadians. And it is about ensuring that those who have historically and continue to be oppressed by institutions receive equal protection under the law. We cannot do this unless we know precisely where inequality exists. Thus, we must require the respondent to collect disaggregated race-based data. Today, I will be making the following submissions. First, I will speak to the decision that to not collect race-based data is a decision that is not political in nature, but rather a matter of justice that calls for the imposition of positive obligations on the respondent. Second, I will address the Section 7 analysis, specifically that all three protected interests were all infringed and that this deprivation is not in accordance with the principles of fundamental justice. Third, I will address the issue regarding concerns about surveillance and the misuse of data, as well as the Charter failing in its protection of minority and group rights. Turning to my first submission, which is found at paragraph 19 of the appellant's factum, the appellant submits that the disproportionate impact the COVID-19 pandemic has had on him is a matter of racial injustice and is not a political decision that is ultra vires of this honorable court. Further, this case is concerned with the legal limits of these rights and whether the respondent can provide healthcare services without the data in a way that does not infringe Section 7. This is supported by Justice Lemaire in reference re Section 94.2 of the Motor Vehicle Act, where he held that the courts are empowered, indeed required, to measure the content of legislation against the guarantees of the Constitution. The Supreme Court in the same decision also articulated that matters of justice are within the sphere of judicial activity. In Chowley, Justice Deschamps indicated that when social policies infringe rights that are protected by the Charter, the courts cannot shy away from them. And that while the decision about healthcare systems should fall with the legislator, the resulting legislation is subject to constitutional limits. Just because a matter is complex or laden with social contentions does not mean that the court can shy away from their responsibility.
Ms. Sinner, your client's position is that the government has failed here by failing to collect any disaggregated data, specifically targeting the Black community. And that's as a result of not collecting data, correct?
Sorry, if I can understand, our position is that the failure to collect race-based data is a responsibility of the court. Is that what you're asking?
No, your contention is that the government has breached Section 7 of the Charter by failing to collect any race-based data, correct?
That is correct, yes.
So what do you submit as the government supposed to do with any race-based data that it collects?
So Justice, the data collection is just one step in the process. It has to also be supported by governmental action. That is beyond the scope of this particular case, but we're submitting that the data that is required should inform policy. So without allocating, my apologies. When allocating resources, it does need to be informed by the race-based data.
Isn't your complaint really, though, that with respect to the government inaction, not in collecting the data, but in that you say that there's a demonstrated need for the government to be doing more from a policy standpoint, and that the government's failure to do that is what's disproportionately impacting Black Canadians?
That is correct, Justice.
What I'm trying to understand, though, is what's the correlation between not collecting the data and that disproportionate impact that you say is borne out in this case?
So Justice, the appellant's position is that without the data, resources cannot be allocated and systemic discrimination cannot begin to be combated. It is the appellant's submission that the standard of whiteness is applied in the medical field, and that without understanding that the severity and the extent, misdiagnosis, underdiagnosis will continue to result, thus resulting in an infringement of the appellant's rights under life, liberty, and security of the person.
And the government data that you say that should be compiled is not only who's getting sick, Ms. Ebo already mentioned about where they're getting sick, if there's death. Is there any other data that you submit on behalf of your client that the government has an obligation under Section 7 of the Charter to be collecting?
Certainly. So social determinants of health are one aspect of the data that needs to be collected. We're not entirely sure how COVID-19 impacts the Black community potentially on a biological level. So without having the full picture of this data, it does infringe the appellant's charter rights.
So I guess to the point, your submission is that, I mean, the government's relying on the paucity of evidence to say there's no demonstrated causal connection, but the government's the reason why that there's no evidence available because it's refusing to collect that evidence.
Well, Justice, the government is collecting data. The government is collecting data from a colorblind approach. So they're collecting data that speaks to age, that speaks to employment status, speaks to pre-existing health conditions. But without understanding the way in which race is infused in that is what is the crux of the argument here, is that we need to understand the way in which race impacts all of those other aspects as well. As I will discuss in my second submission, this case does trigger Section 7 and therefore does fall within the purview of the courts to ensure that the respondent's decision is constitutionally compliant. Turning to the question of positive rights, as my co-counsel has already articulated, there is ample room in the Charter and the case law for this honorable court to interpret Section 7 in a way that imposes positive obligation. Chief Justice McLaughlin, as she then was in Gosselin, held that Section 7 may potentially be interpreted to include positive obligations. In the Queen and Big M Drug Mart, Justice Dixon also stated that an interpretation of the charter rights should be generous rather than legalistic, so as that it is aimed at fulfilling the purpose of the guarantee and ensuring the full benefit of the charter's protection. And lastly, in Blanco, at paragraph 188, the Supreme Court held that the courts should be aware of the need to safeguard a degree of flexibility in the interpretation and evolution of Section 7. To breathe life into Section 7, a reading in of positive obligations is necessary. This is especially true in times of crisis. It is these moments in our nation's history that call for a re-examination of how these rights are to be interpreted. Doing so gives effect to their true purpose of preventing state laws or actions that interfere with Section 7 rights. Turning to the Section 7 analysis found at paragraph 24 of the appellant's factum, the appellant submits that the failure to collect the data violates all three interests under Section 7 of the Charter. Section 7 protects everyone's life, the right to life, liberty, and security of the person, except in accordance with the principles of fundamental justice. A two-step analysis is used in order to determine whether the Section 7 right has been violated. First, there is an identification of the interest in question, and then a determination whether that protected interest has been infringed. And second, there must be a determination whether the infringement is in accordance with the principles of fundamental justice. This requires, firstly, an identification of the relevant principle, and then secondly, whether the infringement of the protected interest occurred in accordance with said protected principle. I will now turn to each protected interest in turn. So by failing to collect the data, the respondent is exposing Mr. Williams to an increased risk of death and thus triggers his right to life. Without knowing the specific causes or social determinants of health, the experiences of the COVID-19 pandemic remained largely invisible on the Black community. When there exists a gap in information that has the effect of jeopardizing the lives of the appellant and the Black community, it cannot be said that the respondent is adhering to her mandate and helping Canadians maintain and improve their health and ensuring that high quality services are accessible to everyone. It is submitted that when this happens, the right to life is violated. The right to liberty is engaged as there's been a deprivation of personal autonomy that goes to the core of Mr. Williams' individual dignity. The appellant submits that without the data, the healthcare system remains largely predicated on a standard of whiteness. This limits the course of medical treatment available to the appellant. Mr. Williams is therefore unable to choose the proper course of medical treatment, resulting in diminished or inadequate healthcare. Nothing is more fundamentally inherently personal that goes to the core of what it means to enjoy individual dignity than the ability to choose a course of medical treatment.
Well, what evidence is there in the record or information available to fortify your submission that Mr. Williams is being deprived of the ability to have effective health care as a result of the government's inaction in collecting race-based data?
Justice, it's the position of the appellant that within the medical field, there exists medical racism, which is the systemic racism against people of color within the medical field. This is predicated on a standard of whiteness. So when medical professionals are trained only on white skin, they cannot treat different tones of skin. So for example, one of the symptoms associated with COVID is blue toes, blue fingers, blue lips, and a red rash. This appears quite evident on white skin, but does not appear the same way on darker skin. It is a position that when this occurs and the misdiagnosis or underdiagnosis of COVID goes, the appellant is not receiving adequate care. Without the data to understand this will continue to infringe the appellant's rights. The appellant's security right is infringed because the failure to collect data imposes an increased, dangerous, and potentially fatal outcome on the appellant, like I had suggested earlier, via inadequate medical care and resources. This is supported by the alarming statistic that the highest number of COVID-19 cases were in neighborhoods with Black communities, that Black people account for 21% of all cases in Toronto, while making up only 9% of the overall population. That 71% of those hospitalized with COVID are racialized people. A recent report from a CBC journalist has actually shed more light onto these numbers and has suggested that this 21% has increased to 28%, thus exacerbating the need for the race-based data.
The source of your information for that statistic is what? The paragraph 29 of your factum makes that same statement, and then the footnote is the Schwelle Supreme Court decision. I wasn't sure, at least from the factum, what the source or evidentiary basis for that stat.
My apologies, Justice. That is actually an incorrect error. I will pull up the actual source for that in 1 second. Let me find our source list here.
And I don't want to throw you off your submissions, so if you want to come back to it, that's certainly fine for me.
Okay. I know it is in one of the news sources that is provided. Let me just take a look here. I believe it is in the Sana Halwani article, but I would have to confirm if I could just continue with my submissions and I can come back to that.
Thank you very much.
Thank you. The appellant's security right is infringed. Oh, my apologies. I'm going back here. Turning to the second step in the Section 7 analysis, found at paragraph 30 of the appellant's factum, the appellant submits that the deprivation of Section 7 in the case at bar is not in accordance with the principles of fundamental justice, because equality is a principle of fundamental justice. Cases like Carter, PHS, and Gosselin all point to the court's willingness to expand the principles of fundamental justice to include equality. In the Queen and Malmo Levine, the Supreme Court outlined a framework in assessing the principle of fundamental justice. That test is outlined at paragraph 31 of the appellant's factum. At this point, I would like to direct the court to the crux of this argument, which is namely the third criteria of the Malmo Levine test found at paragraph 34 of the appellant's factum. So it is the position of the appellant that equality can be sufficiently defined for two reasons. Firstly, equality is entrenched in the Charter, the grounds of which are set out in Section 15. Therefore, the parameters and scope of equality claims are sufficiently known. Secondly, if this honorable court continues with the judicial trend of interpreting equality to mean substantive equality, as seen in Andrews and Alliance, and incorporates an intersectional analysis within the Section 7 framework, it is submitted that a sufficient definition of equality can be discerned. An intersectional analysis includes acknowledging the various configurations or sites of oppression because of an individual's various identity markers. The lack of consistency among judges to contextually consider the Section 7 claims of marginalized individuals reveals the need for structural change to the Section 7 analysis. It is this court's role now to solidify this trend and bring meaning to a right that has been for so long ignored and underutilized. Turning to the appellant's first theoretical argument under Section 7, found at paragraph 36 of the appellant's factum, the appellant submits that although there are legitimate concerns regarding the implications on the use of this data, such as over-surveillance or distrust towards the government, this concern cannot overpower the need for it. The data will bring to the forefront the long history of racism, socioeconomic inequalities, and other sites of oppression that would otherwise be unknown. As a result, the data can be a catalyst in governmental change and is therefore imperative in addressing anti-Black racism in healthcare. By eliminating the availability of the data, rather than regulating and controlling its use, perpetuates and in fact continues the erasure of medical racism that the appellant faces. The claim that this data will be misused lacks merit. The alleged misuse will still be subject to all constitutional challenges. It is the appellant's position that fear of a potential cannot dissuade from taking action when the reality of the matter is that the health of the Black community is in jeopardy. Turning to the next theoretical argument under Section 7, found at paragraph 39 of the appellant's factum, the appellant submits that the Charter has been interpreted in a particular manner that is focused on an individualistic notion of rights predicated on a westernized version of liberalism. This version presumes individuals are self-interested, detached from their community, and presumes a universality of rights, the applicability of which will protect everyone equally. This is incorrect. This interpretation, similar to formal equality, has left the rights of groups largely unprotected. Unprotected in the sense that when these groups seek to address systemic disadvantages that are culturally specific, they cannot turn to the Charter for remedy as those rights are not recognized. The individualism protected by the Charter in Section 7 strips the appellant of any opportunity to address systemic discrimination faced by the Black community. By reframing the Charter, specifically Section 7, to include rights, this court has the opportunity to expand rights for those most marginalized. I see that my time is up, Justices. I will rely on the remainder of my factum for my submissions. May I have a brief extension of time to conclude?
Yes, go ahead. You have 30 seconds.
Thank you.
We have read your factum.
Okay, thank you. Justices, today's actions will set the course for tomorrow's rights. In order to make promise of justice under law, this court must consider the ways in which the respondent has failed to protect the health of the appellant in its decision to not collect the data. As such, this court must find that the appellant's Section 7 and 15 rights were violated and find that the Supreme Court of Canada erred in their decision that they were not. The rights protected by Section 7 and Section 15 have become embedded into the very DNA of Canadian identity. Nothing can weaken this DNA more than failing to protect and assert those rights. It is therefore incumbent on this court to ensure that the law as currently formulated does not continue to be a tool of oppression. Justices, this decision has the opportunity to shape and set out principles that will guide the future of Section 7 litigation. If there are no further questions, these are my submissions.
Thank you very much, Ms. Cinerari and Ms. Ebo, both. Thank you. I'm wondering if we could maybe take a 15-second break before we move, maybe more than 15 seconds, 90 seconds before we move into hearing from the respondents. Does that suit you, my fellow Justice Statham?
Yes, thank you. Good evening, respondents. If everybody's ready, then perhaps we'll continue. I'm not sure, Ms. Hugh, whether you're first or Ms. Steppa, if you're going to be first response counsel. But please go ahead as you wish.
Sure. Good evening, Justices. My name is Olivia Hu, and today my co-counsel Eunice Stappa and I are submitting to the Diversity High Court on behalf of the respondent, the Minister of Health. The respondent submits that the minister's decision to not collect race-based data does not infringe Mr. Williams' Section 7 or Section 15 charter rights. Justices, this case is about protecting all societal interests during a pandemic, where government actors are required to balance a multitude of interests to protect those living in Canada effectively. This case is not about opening up the floodgates of imposing positive obligations to collect race-based data. Justices, this appeal provides this court with an opportunity to maintain provincial autonomy regarding healthcare, specifically collecting race-based data. And further, courts have not viewed a positive obligation regarding this and should not be taken lightly, especially in unprecedented times such as the pandemic. The respondent seeks for this honorable court to dismiss the appellant's appeal and maintain the order of the Supreme Court of Canada. I would like to orient the court with a brief roadmap of the respondent's submissions today. First, the lack of collecting race-based data does not trigger Mr. Williams' Section 7 charter rights because no positive obligation exists to collect this type of data and no positive obligation should be enforced. Second, the minister's decision to not collect race-based data does not infringe Mr. Williams' Section 15 rights because COVID-19 is affecting people across the globe, regardless of race and socioeconomic status. Third, in the alternative, if collecting race-based data is necessary, this responsibility should be upon the provincial governments and municipal governments to do so, especially during a pandemic, as the different levels of government are working to deliver healthcare services effectively. I will be discussing the submission that Mr. Williams' Section 7 rights are not triggered. My co-counsel Eunice will submit the arguments on Section 15 and the theoretical arguments regarding collection responsibilities. Justices, the minister's choice to not collect race-based data does not trigger Mr. Williams' Section 7 rights. The respondent submits that Section 7 is not triggered for 4 reasons. Section 7 is not triggered because collecting race-based data is a policy argument that the courts should not interfere with. Second, Section 7 is not triggered because there is no positive obligation on the minister to collect race-based data. Third, the dichotomy between positive and negative rights should remain separate. And fourth, there is no sufficient connection between collecting race-based data and Section 7.
Ms. Hu, your friends have relied upon evidence establishing that Black Canadians account for 21% of reported cases in Toronto while making up only 9% of the overall population. Do you take issue with that statistic?
There are a multitude of social determinants of health, and while the respondent understands and that systemic racism is extremely prevalent in Canadian society, the multitude of different social determinants of health, race only being a factor of it, is not race only being a factor of it and this specific case focuses on that. However, it is the respondent's submission that regardless, this is not an argument that the courts should interfere with.
But doesn't that lend credence to your friend's submission that race is a relevant factor to why some Canadians are being disproportionately ill and in more acute cases dying? Race being one factor, there being other social determinants as well, but there seems to be evidence that race is a relevant factor, and with the need for disaggregated data, individuals directly affected and indirectly affected would be able to have a better idea, and the government would be optimally positioned to respond to those health causes.
It's a great question, Justice, and I wish it were that simple. While race is a factor, it is only one factor, and this case is about imposing these positive obligations on the government that would and potentially open up a floodgate of issues, as Justice Brown put it in the Supreme Court decision of this decision. For how many races do we collect data for how many healthcare aspects? This is something that the judiciary will likely not be able to predict, and it sets a precedent for future cases.
In your factum, you rely upon a number of authorities where the courts have been asked to take issue with the government's approach to the implementation of social policy. Isn't the different feature in this case that the government's total inaction as opposed to apportioning insufficient resources towards a policy program? This case is about implementing no resources into the collection of data related to, as you say, a problem affecting individuals across the country, not just one province.
This case is about inaction, and that is precisely why it differs from the other cases where courts have imposed an obligation to reinstate a program. For example, I understand in my factum, I will just direct the court to it if I may. At paragraph 12 of the respondent's factum, Victoria City and Adams, where homeless people were erecting structures for shelter, the government infringed on the claimant's Section 7 rights by forbidding this action. And Mr. Williams' case is distinguished because the minister does not prevent Mr. Williams from protecting himself from COVID-19. The lack of, or the decision not to collect race-based data doesn't affect his ability to seek out healthcare for COVID-19, and he has continued to be entitled to treatment. Justice, if I may, another case, downtown Eastside, which my co-counsel will discuss in further detail, is also different from the respondent's case or the appellant's case, because in downtown Eastside, the government stopped a program and the courts reinstated that, or obligated the government to reinstate that program. This case here is different because there is no existing legislation at hand, and the minister has the power and discretion on how to collect data.
But if there is already evidence that Black Canadians are being disproportionately impacted by this virus, and the further collection at a national level in an organized fashion could show or would show a constant greater impact, might that not ultimately reinforce that segment of the population getting prioritized with vaccination? My point being, the present impediment in the government's hands with collecting race-based data could, from at least some of the evidence that your friends have provided at this point, reinforce actual steps that we would expect the government to take in order to prevent those foreseeable harms to Black Canadians.
Justice, I would have to disagree with that. I would say no, because simply collecting this race-based data does not ameliorate or impose or create that obligation on the government to take those policy steps. And again, it's that decision is something for the legislature to decide. It's something that the minister has the power and discretion to decide. And so it does not automatically or ensure that these policy steps will be taken. And
I'd like to interject here and just remind ourselves of the not too distant past when Statistics Canada came under some fire to change its census questionnaire to make it less granular. And there was quite a reaction from many communities, not just academics, regarding that damage to Canada's ability to govern itself, and for us to make appropriate policy decisions based on data, and carrying out longitudinal studies, how that was interrupted, and so on. When I look to your paragraph 12 and the case Victoria versus Adams, I see something more akin to a parallel with Vreend, and I'd like you to address that. Because in your paragraph 12, you say that the appellant, Mr. Williams, can continue to seek out healthcare for COVID and is entitled to treatment. but that's not what's an issue. The nature of the treatment he receives, if it's not informed by intelligent medical research and intelligent medical personnel who gets to learn something about the relationship between race and the symptoms, how they manifest themselves, or the relationship with race and other pre-existing conditions like genetic disorders. I believe Ms. Ebo referred to the sickle cell gene, for example, which does not affect European populations. It's quite common in Southeast Asia, in Africa, and the Caribbean. Do you not see that your paragraph 12 actually flies in opposition to the court's decision in Vriend that says that when you show up for healthcare, you're entitled to receiving healthcare without the barrier of not having ASL interpreter, or in this instance, not having an intelligent doctor who's attuned to race and its impact on the doctor's own ability to deliver care. There's a question in there. I know
Yes.
I've made it into an argument, but is this not more akin to Vriend?
No, I would say
effective delivery of health services requiring positive action.
I would say no, because one, I would like to point, I would like to, the respondent submits that this positive obligation is a really high threshold, first of all, and because there is no sufficient causal connection that the respondent found between Section 7 and collecting race-based data, the link is speculative as applying the reasoning in Bedford, and the respondent submits cannot be satisfied on this balance of probabilities. And so I would say, no, this is not more akin to Vriend, because the effectiveness of healthcare is determined on a multitude of factors, race being one, and all are important. How are you to determine which one is more important when there are so many different factors? And again, reiterating back to the point, this would also open up this floodgates issue of how many healthcare aspects will the government be obligated to collect for, and imposing this positive obligation on an inaction that the government is doing is something that the courts have not imposed in the past. And in such unprecedented times, such as the pandemic, this distinction and this determination should be kept even more separate. And I understand, and the respondent understands, that while the charter is a living tree, it should be developed as novel circumstances arise. And again, while the pandemic does fall under one of those novel circumstances, enforcing this positive obligation on the minister to collect race-based data is not a small incremental change to interpreting the charter. I'd like to point the court, if I may, to paragraph 8 and 9 of the respondent's factum, where we cite British Columbia AG and Christie, where the court also did not impose a positive right to state-funded counsel in judicial proceedings involving an individual's legal rights. And there, the court didn't impose that positive right, and similarly, imposing that positive right on the minister in this case to collect race-based data creates this broad action that I've mentioned previously in my submissions that would open the floodgate for various claims regarding data collection.
I'm going to ask you to take a look at paragraph 7, because I actually was very concerned when I read paragraph 7, where there's a reference into Gosselin and special circumstances where the court could impose a positive obligation. And you cite there the consequence of the pandemic from the non-collection of race-based data is not a special circumstance. I'm not sure I understand what that means, but my question to you is, if the pandemic is not a special circumstance, what is?
That I think is beyond the, is
To give you an
something,
example, what would be a special circumstance outside of Gosselin? What would be another special circumstance if a pandemic doesn't qualify?
Your Honor, I believe at Section 7, the pandemic itself is a special circumstance, but the consequences of the pandemic and the positive obligation to collect race-based data is not a special circumstance.
Okay, very well. All right.
And along with that, this issue does not end. The collection, the floodgates issue I've been mentioning does not end when the pandemic ends. It has that potential to trigger and snowball into bigger effects. I mentioned for how many healthcare aspects, for how many data sets, and during a time when the number of COVID-19 cases are rising and the overwhelming healthcare systems, and adding that obligation to the system further strains it.
But the strain that you're alluding to is the strain involving doctors and frontline workers that are working in hospitals and health facilities, not the statisticians who are presumably removed from those facilities and have technological capabilities of obtaining the sought information here in other ways.
The frontline workers are doing, they are taking the crux of this pandemic. However, the response that the government is taking and the implementation of procedures and is something that takes time and effort and will require that obligation for them to consider many different factors. For example, collecting race-based data would only be one of those factors. And while the government is working extremely hard to ensure that they are responding to the pandemic effectively, the respondent submits that this is not an obligation that should be added. Justices, in the alternative, the respondent submits that if Section 7 is triggered, the minister's decision to not collect race-based data does not infringe the appellant's Section 7 rights. This begins at argument E at page 9 of the respondent's factum. First, life is not infringed because the disparities of COVID-19 are known without race-based data. The mere lack of data does not directly or indirectly increase the appellant's risk of death. The respondent understands the consequences and the importance of systemic racism, the consequences, and the appellant argues that without knowing the specific causes or social determinants of health, the government cannot allocate resources and direct policy initiatives. However, the social determinants of health are not unknown. Income and social status, employment and working conditions, physical conditions, and gender are all specific social determinants of health. Race is one factor among many. Second, the appellant's claim does not meet the two components for a liberty infringement. First, there is no physical restraint directed at protecting the appellant. And second, the failure to collect race-based data does not restrain the appellant's right to make this inherently private choice. He is still free to move around and make personal decisions under his autonomy. The appellant submits that Mr. Williams is unable to choose the course of his treatment because healthcare focuses on whiteness. However, the respondent submits that even if the government were to collect race-based data, it would not automatically ameliorate any system or any racism or systemic racism in the healthcare facilities. And third, security of the person is not infringed because there is no evidence that the failure or the decision to not collect the specific type of data will prevent Mr. Williams from making inherently private choices. There's adequate access to other types of information that are included as part of social determinants of health. There's no state action here, and there's no evidence that this specific data will have a profound and serious effect. Justices, To conclude, the respondents submit that the minister's choice to not collect race-based data does not engage Section 7. There is no positive obligation, and the court should not enforce this positive obligation on the minister to collect. As I've mentioned previously in my submissions, this would open up the potential for a floodgates of different issues, especially during a time such as the pandemic. This would set a precedent for different issues. And yes, Justice.
Sorry, I didn't mean to throw you off. I just wanted to ask you, there obviously are ways in which, should we disagree with you, we could circumscribe the obligation on the part of government in order to collect data here. My colleague has already alluded to the exceptionally unique situation that we find ourselves in, namely in the middle of a pandemic. It seems to me that one way in order to address your floodgates argument is to obligate the government to take action now because of this pandemic. Would that not be an example of how a response could be fashioned in a way that would avoid overwhelming the government, but at the same time respect the life, liberty, and security of Black and other racialized Canadians?
Justice, if I'm understanding your question correctly, you're asking if imposing this obligation for the pandemic period itself and no longer would satisfy both would satisfy my floodgates argument and also not infringe the life, liberty, and security of Mr. Williams. Am I understanding that correct?
I'm asking you if you would agree with that position.
I would not agree with that position.
And if you could explain why, please.
Sure, I would not agree with that position because, like I've mentioned, this sets a precedent, and while this obligation is a high threshold, and even though the pandemic may be a special circumstance, this obligation is not sufficiently connected to Section 7 for it to even be triggered. Justices, I see that I'm running out of time. If I may conclude on one last point. Again, like I've mentioned, there is no positive obligation, and the respondents submit that the court should not enforce this positive obligation on the minister to collect the data. And that concludes the respondent submissions on Section 7. I'll turn over to my co-counsel Eunice for her submissions on Section 15 and our theoretical argument.
I have one question before you do. Your factum doesn't address Section 1 of the Charter because you say there's no breach. What I would like your position on is if we disagree with you and were to find either a breach of Section 7 or 15 or both, could that breach be saved under Section 1?
Yes, it could be saved under Section 1. And while Section 7 is difficult to be saved under Section 1, the Ontario Court of Appeal did so in R.V. Michaud, where the appellant was charged with having a speed limiter on his truck. And the respondent believes that this is precisely also the case that aligns with Michaud. There is no law or omission that the minister is acting upon. Even then, if we look at the requirement that the limit is to be reasonably and demonstrably justified, the respondent submits that not collecting race-based data does not meet those requirements.
Thank you.
Thank you, Justices.
Sorry, I didn't mean to cut you off. I thought you were done.
Thank you, Justices. That concludes my submissions.
Thank you.
Good evening, Justices. My name is Eunice Dappa, and I will be presenting the respondent submissions on Section 15 of the Charter and the critical race theory argument. My submissions begin at paragraph 25 of the respondent's factum. The appellants have submitted that the minister's failure to collect race-based data infringes upon Mr. Williams' Section 7 and Section 15 rights. My friends have centered the bulk of their argument on racial injustice and inequality in Canada. Respectfully, this case is not about that. This case is rather about whether or not the minister has a positive obligation to collect race-based data for the COVID-19 pandemic. Such an obligation would be imposed if the failure to collect data infringed on either Section 7 or 15 of the Charter. Again, this case is centered on whether there's a positive obligation on the federal government to collect race-based data, not on whether or not the government has responded to racial inequalities in society. I will outline the respondents' arguments by highlighting that the lack of race-based data collection does not infringe on the appellant Section 15 rights. My analysis proceeds in 3 parts. First, I outline the legal test for Section 15 to emphasize that there is indeed no mandate or law requiring the collection of data, race-based or otherwise. Then I explain that Section 15 does not impose a positive obligation on the minister, and therefore charter obligations cannot be instituted where the right does not exist. Lastly, I conclude the Section 15 argument by highlighting that the collection of race-based data is not synonymous with the provision of healthcare. Section 15 of the Charter outlines equality protections. More specifically, the Charter provides equality and the protection and benefit of the law without discrimination based on race, color, sex, etc. While the appellant argues that Section 15 is engaged because failing to collect race-based data equates to discrimination, in fact, race-based data collection is not mandated under the law. The lack of collection does not meet the equality test set out by the court in law in Canada as a requirement for a successful Section 15 claim. The test states that the claimant must establish differential treatment under the law on the basis of an enumerated or analogous grounds, which constitute discrimination. In this case, the law does not confer the benefit of race-based data collection. The appellant cannot ground a current Section 15 claim in a non-existent benefit because there is no duty or obligation to collect race-based data. As iterated by the Supreme Court in Ottawa and British Columbia, there can be no administrative duty to distribute non-existent benefits equally. It is the respondent's position that the appellants cannot ground a current Section 15 claim on the non-existent benefit of imposing the collection of race-based data. In order to succeed in this claim, the appellants would have to show that there was an existent law that mandated race-based data collection, and then prove that the benefit was being conferred inequitably. Again, currently, no law legislates the collection of race-based data. While assessing the law as a living tree has been an argument, we cannot conflate the hopes and desires for a more utopian society with a positive obligation on the minister to enforce an unwritten law and guarantee a non-existent benefit.
Ms. Deepa, I want to follow your argument. I like that fact that you've laid out clearly that you have 3 parts to it, but I'm having difficulty with the first part, so I don't want you to go too much further ahead. You speak of a non-existent benefit. Is healthcare not an existing benefit?
When I speak,
Williams is seeking, appropriate access to healthcare, appropriate to his race and the conditions associated with his race and particular diseases or propensities for negative outcomes. Is that not itself the benefit that he's seeking?
So when I assess Mr. Williams' claim in this case, we attribute the benefit as race-based data collection. Health in and of itself is being considered, and I will address that later on in the arguments when I state that the fact that Mr. Williams still has the ability to get treatment for this disease or the ability to seek treatment is being conferred. Here we distinguish the non-existent benefit as the benefit of race-based, so particularly race-based data collection. In this case, it would be data collection pertaining to Black individuals specifically.
But no one seeks data just because they like numbers. Nobody. The numbers themselves are not beneficial.
I would agree with
not necessarily detrimental. It's what you do with them. And the entire point of this exercise is in pursuit of health in the face of, lethal pandemic. So why are we recharacterizing it to talk about numbers as if someone is interested in abstract numbers rather than health outcomes, life and death? Why are we shifting the focus?
So for the respondent's position is that the crux of this argument relies on imposing a positive obligation on the minister. So in this case, it's imposing the positive obligation to collect race-based data collection. We're not negating that health is an important factor, and we're not negating the fact that there are circumstances such as socioeconomic factors that play into health, which I will discuss later on in the arguments. We're not negating those fundamental issues. What we are saying, though, is that the focus is shifted because now we're imposing a benefit, which is the collection of specifically race-based data. I do agree with your point that nobody seeks out numbers just for seeking out numbers' sake, but we are making this statement or assertion that in this case, the benefits imposed are not sufficient enough because he still gets the treatment that is required, especially with the pandemic being such a novel pandemic. There are still, issues that are being dealt with on a different basis. When I get to my critical race argument, I will assess the fact that supposing race-based data needs to be collected, it's the respondent's position that it should be done so on a different level of government. So it should be an issue that is addressed with the provincial government rather than the federal.
But for you to get there, you have to admit it is a benefit. Before you shift responsibilities to the other level of government, you would have to completely undermine this initial argument, which is, it's not a benefit.
So we believe that race-based data collection specifically is not a benefit, but the data collection or healthcare is a benefit which is being conferred.
Okay, very well. Continue. I'll try to follow the rest.
Alrighty.
Thank you.
So when it comes to Section 15, it's the respondent's position that it does not impose a positive obligation on the minister. The court, Justice McIntyre in Law in Andrews and Law Society said that discrimination in Section 15 is limited to what is caused by the application or operation of the law. In the same case, the court found that despite the inequalities in society, there is no positive obligation on the government to take steps to eliminate all disadvantage in society. Furthermore, the Supreme Court in downtown East Side found that it is only when policy is translated into law or state action that it can be subject to charter scrutiny. In accordance with the ruling of—
But the Canada Health, sorry to interrupt you, but the Canada Health Act, a piece of federal legislation, states under Section 3 that its very purpose is to protect, promote, and restore the physical and mental well-being of residents of Canada, and to facilitate reasonable access to healthcare services without financial or other barriers. It's a piece of federal legislation. Its stated purpose is to facilitate reasonable access without financial or other barriers. I take your point that this appeal isn't about social discrimination, historical discrimination at large. Your friends would argue that that actually feeds into and perpetuates the disproportionate impact on Black Canadians here. But given that there is a piece of legislation that states as its purpose that objective, and that there is evidence in this case that Black Canadians are being disproportionately impacted, therefore their ability to get meaningful access to healthcare and, to wit, effective treatment. I mean, doesn't that in and of itself make out the threshold for Section 15 to apply, at least?
We would respectfully disagree with that supposition. Although there is healthcare being provided to, I would start by saying healthcare is being provided to both Black Canadians and other racialized groups in society currently. And the novelty of the pandemic calls for resources to rather be spent towards coming up with things like vaccinations, taking measures such as quarantine, which the federal government deals with, and other measures which would promote overall equality and overall health, specifically when it dilutes down into issues, racialized issues with Black Canadians. Here, it's not that the pandemic has caused treatment not to be given specifically to Black Canadians, but I think whereas the issue should rather be that the pandemic should cause treatment strategies to be figured out so that the delivery of treatment can be more effective.
But doesn't statistical evidence enable stakeholders like the government, by extension the public here, in order to decide how resources need to be prioritized, whether it's vaccination or other treatments? And so if Black Canadians, for example, are being disproportionately impacted and are biologically and or socioeconomically more likely to be impacted, I mean, isn't that indicative of the responsibility on the part of government to act in a way that is going to alleviate, to the extent that government can, that disproportionate impact? And I take that to be the crux of your friend's submission, so it would assist me to know what your counter response is, at least on that point.
Sure. To your point specifically, I think if it is such that Black Canadians specifically are being impacted by this disease more so than other Canadians, if we take that point as fact, I think government resources should rather be put towards alleviating or addressing other circumstances that contribute to health. For example, if we look at socioeconomic factors, there are historical references to socioeconomic factors speaking towards impediments in education, impediments in work privileges, impediments in food, impediments in a lot of things that result in impediments in health. So I think government resources should rather look to alleviate the factors, the major factors that play into even getting a Black Canadian, if we want to look at that minority specifically, even getting a Black Canadian to the point where they're more able or more susceptible to COVID-19 factors. I think the factors surrounding healthcare should be addressed and should be taken care of in response to that question. As I was mentioning earlier, there's no differential treatment that discriminates against COVID-19 patients. The failure to collect race-based data does not equate to a differential treatment in COVID-19. The court in Aton stated that the specific role of Section 15 is to ensure that when governments choose to enact benefits or burdens, they do so on a non-discriminatory basis. The claimants in Aton argued the benefit provided by the law was funding for all medically required treatment. However, there was no governing legislation to provide such a benefit. The exclusion was not discriminatory because the claimants could not establish that the law created a discriminatory effect. Furthermore, as explained in Whittler, a distinction is created if the claimant is treated differently than others, or if the claimant asserts that he or she is denied a benefit that others are granted by reason of a personal characteristic that falls within the enumerated or analogous grounds of Section 15. The appellant's claim in this case would carry greater weight if the appellant was denied access to information or benefit that others received because of race. And the respondent does agree that race is a social determinant of health, as I was saying, that causes overrepresentation of marginalized groups in the healthcare system. Nevertheless, overrepresentation of vulnerable groups is not sufficient to meet the first branch of Section 15 when the vulnerable group is treated the same as everyone else. In the case at bar, the appellants claim an infringement on their rights based on racialized standing. However, they failed to establish how not collecting race-based data treats the appellant differently from the rest of the population, which results in discrimination. If the minister had a law providing a benefit to the appellant, this case would move in an entirely different direction. However, although race is an enumerated ground from which to derive differential treatment, the appellant cannot otherwise make a Section 15 claim. So just to conclude the Section 15 argument, they cannot meet the Section 15 test because the collection of race-based data is not a benefit provided by the law. Section 15 does not impose a positive obligation on the government to collect such data, and the provision of care persists despite the non-collection of race-based data. Therefore, this honorable court should uphold the decision made by the Supreme Court of Canada and find that the Section 15 claim should be unsuccessful. I'd like now to move to the—
Sorry, I didn't mean to cut you off. I think I have a delay with my internet. I just wanted to ask you, we touched upon already the Healthcare Act. Another piece of federal legislation is the Access to Information Act, which, as I'm sure you know, gives Canadians the ability to make a records request and access those records from federal government institutions. Could it not be said that when you combine the purpose of the Healthcare Act with the purpose behind the Access to Information Act, that in effect triggers a statutory obligation on the part of the federal government to do what they say in this case the government should be doing, because of the need to have meaningful records, meaningful access to healthcare, and meaningful treatment?
The nature of the Freedom of Information Act, as I understand it, is that you have to apply to get your information, especially as it pertains to hospital records. You would still have to apply to obtain that information. As it pertains to the Information Act in combination with the Health Act, it sort of moves towards our critical race theory argument, specifically because with the division of powers as it persists to healthcare, the provincial government, we feel, is in a better position to deliver or to collect the information and to eventually deliver on the use of that information, specifically because the provincial government has a more contextualized touch with the people with whom fit into their borders. Specifically, when you collect race-based data on marginalized communities, the provincial government would be better able to determine, for example, I believe it's 3.7% of the population is Black, but it's in clusters in different regions. So the provincial government would be better able to assess how to address what is on hand in the area, in the region, rather than a blanket approach taken from the federal government mandating the collection of data, which could speak to costs, which can speak to, as my co-counsel said, a floodgate of arguments or a floodgate of issues that can be mandated by the federal government. Rather, if it's provincial, you're getting location-specific data, location-specific assurances to the people that are affected. Does that answer the question?
Thank you.
No problem. I do see I'm running low on time, so I will proceed quickly through the critical race argument. As I said earlier, I mentioned a lot of our argument. The crux of our argument is that it should rely on the provincial government, who's better equipped to collect race-based data because they can better understand the marginalized communities. And collecting race-based data in that sense should take a bottom-up approach with the municipalities, the provinces, rather than the federal government. To date, actions such as quarantine and travel restrictions have been put in place by the federal government, as depicted by the nature of the stay-at-home doctrine. But it's respectfully submitted that to deal with COVID-19 from a critical race perspective, we believe that specifically municipalities, cities, and provinces should implement specific measures to deal with the circumstances on the ground. Just to conclude this argument, or our overall argument, Your Honors, our position is that this case is not about what the appellant deems as the most utopian path for the country. Rather, it's a question of whether there is a positive rights obligation on the minister to collect race-based data concerning COVID-19. The government is under no legislative obligation or mandate to collect the data, and resultingly, we believe that the appellant Section 7 and 15 rights are not infringed. It is for this reasons that Your Honor should affirm the decision of the Supreme Court and find in favor of the respondent. Justices, these are our submissions. Thank you.
Hey everyone, it's over. Congratulations, everyone. Thank you for all for attending the first round of the 2021 Julius Alexander